And we can see here perhaps the most significant change from 1976 is the use of significant quantities of commercial concentrate.
Factor VIII, exposing the contaminated blood scandal.
Oh, vastly. And of course, this was the pattern all across the haemophilia world. I mean, we may even, St George's may even have been slightly slow to replace cryoprecipitate with concentrate. But the massive increase in concentrate and basically looking at that, haemophilia it's cryoprecipitate essentially ceasing to be used because 200 units is less than a single dose. I'd only just seen my first bottle of Factor VIII ever just before starting in 1976 at St George's. And I had essentially no idea of the commercial world of Factor VIII purchase.
Do you know what, if anything, patients were told by Professor Flute about the comparative risks of concentrate versus cryoprecipitate or NHS concentrate versus commercial concentrate?
In strict terms, no. But I would say that neither Professor Flute nor the patients were what we now call fully informed about that, validly informed.
And you've said in your statement that you've got a recollection in 1979 of attending a UK HCDO meeting and hearing a talk from Dr Krask, which effectively led to your understanding that non-A, non-B hepatitis was something to be taken seriously.
Absolutely right. I mean, I'll have to apologise again for memory, which, as we saw in the case of cryoprecipitate, is not a quantitative thing. It's a kind of images stand out, and Dr. Krask was quite a recognisable speaker of the podium. He had a huge shock of white hair, and it was, you knew when you were being talked to by Dr. Krask, and so I just remember that and thinking, yes, well, this authority is taking it seriously, and we all should.
Do you consider that, as a matter of principle, patients should have been told about the risks of non-A, non-B hepatitis and that they could potentially have serious consequences, at least from 1979 onwards?
I think that's unarguable. I don't think anybody would claim that they should not know that, since we knew it by then.
But I think from your earlier answers that, again, please correct me if I'm wrong, you don't know whether Professor Flute's advice to patients changed at all about non-A, non-B hepatitis?
I'm afraid I have no knowledge of that. I would hope it did, but I can't say yes or no. You
put it this way in your statement, having read that you knew that people with haemophilia were at risk of blood-borne infection because of their exposure to pooled plasma from mini donors. So the association, as I understand it, between blood product usage and AIDS seemed quite likely to me.
Yes, at that time, I think I remember describing it as, the person with haemophilia exposed to multi-donor blood products being like the canary in the coal mine for any blood-borne infection, and this would be not just information that led to me regarding them as risk, but also, quite good information suggesting that you were looking at a blood-borne virus.
Given that, to your mind at least, in early 1983, there was a likely association between the use of blood products and the development of AIDS or AIDS symptoms in haemophiliacs, would you agree, as a matter of principle, that patients should have been told of that possible or likely risk at the time?
Well, I think they should have done.
And do you know what, if any, information or advice was given to patients as a matter of fact? may seem from Professor Flute's words to you and Dr. Lee that he may not have given patients warnings, but do you have any knowledge yourself of that?
I really have to say I don't recall any evidence that he raised this question with his patients, and that would be slightly reinforced by my own conversations with them when I actually did, when I shared the news of their seropositivity with them.
And is this correct, that as far as you know, there was no change of treatment policy at St George's in response to the risk of AIDS until the switch to heat-treated products in early 85?
As far as I know, that's the case.
I wanted to ask you next, Dr. Bevan, about some of the reflections you've set out in your witness statement. You say this: to my current knowledge, from hearsay largely informed by subsequent written sources such as Starr's revealing book Blood, during the 1970s and early 1980s, plasma fractionation companies in the USA bid for large pools of frozen plasma assembled from up to 40,000 donors, traded on the North American plasma spot market, Toronto, Canada, by plasma brokers. The companies and brokers who participated in this market maintained a state of willful ignorance of the provenance of this plasma, which was widely known to have contained donations. We'll go to the next page, thank you. From US prison populations, so-called Skid Row blood donation facilities, buying blood for cash from street people, including substance abusers, and even donations forced from Central American villages at gunpoint by paramilitaries. They performed screening for hepatitis B on the plasma forms, but otherwise fractionated them into Factor VIII concentrate. And then you say this: I therefore consider by far the dominant contribution to the scale of infection of patients with bleeding disorders in the US and UK to have been made by the commercial fractionators who made and sold infected Factor VIII concentrate because they knowingly abandoned any control over the safety of their raw material. Another significant contribution to the scale of infection was made by the acts of plasma market makers and brokers involved in the sale of plasma.
We do have some material which has been offered to the inquiry which would tend to support the Central American reference which is set out here.
I mean, that's obviously absolutely horrible to contemplate.
Yes.
You then refer in the next paragraph to Factor VIII companies pulling the wool over the eyes of doctors. I'll come back to that if I may. I'll skip that for the moment. You then say this: however, taking all these things into account, the UK HCDO continued to hold the line well into 1983 that the evidence of an infectious cause of AIDS was inconclusive and that action would be premature long after that position became obviously untenable. However, by then the scale of HIV infection in people with bleeding disorders in the UK was fully established, and obviously that's a matter that the inquiry will have to determine in due course. Now, just pausing there, if I may, I'll come on to hepatitis C perhaps after the lunch break. First of all, are those observations you stand by?
I stand by those observations. Those doctors were in many ways admirable doctors. I would feel embarrassed confronting them with it, but the fact is, I think that they held the line to the point where it almost became like a denial problem into 1983. I think to continue to propose that there was no conclusive evidence that AIDS was caused by an infectious agent was simply, in retrospect, of course, untenable. So I still feel that way, yes.
Mrs. Simpson talks about the defence lawyers looking to strike out the claim. And then there's a long paragraph where Dr. Rejman, representing the Department of Health, gives the government's perspective: no case for an out-of-court settlement, compensation must be sought through the courts, etc., etc. Now, it would appear from this discussion that directors were, to some extent at least, being asked to assist in the defence of the litigation. They were certainly being given a fairly detailed account of the defendants, including the government's response. Can you recall whether at the time that struck you as odd or concerning that directors were being drawn into the litigation for the defendants in this way?
Okay. I kind of remember it because of Dr. Rejman. somewhat... I could say he presented the government's position in a kind of hardline way that struck me as unsuitable, inappropriate.
Thank you. And it's what Mrs. Barbara Simpson was saying. The underlying picture apparently being painted was that the assembled doctors were assumed to have some interest which coincided with those of the defendants in the litigation. And she appears to be asking the doctors present to assist insofar as they could. I've always understood it as a general principle that when asking people who are not themselves, at least currently, being sued for what is expert opinion, that if it's offered, it should be available. If the doctor or other person is invited to give a comment as opposed to make a report, it should be available to both parties so that both parties can see what the individual has to say and the impartiality is not compromised. Do you know whether any inquiry has been made of Barbara Simpson as to the basis of the request that she was making?
I don't off the top of my head, sir. We can certainly find out.
Because it might be a matter of importance. Well, it has to take into account that it's at a time perhaps before Mr. Justice Creswell set out in the Icarian Reefer the general principles of how experts should behave, etc. But it was well known that if individuals were suing doctors who had been involved in their treatment, that they ought to be freely available to go to other doctors who would be under no sort of pressure one way or the other to say anything to the would-be plaintiff other than what they really thought, and the defendant similarly.
Yes.
Factor VIII, exposing the contaminated blood scandal